May it please the Court. My name is Jake Mathis and I represent the appellant in today's case, Joseph Fisher. Mr. Fisher was convicted by the trial court of interference with the flight crew, and this court should reverse the trial court's decision for two reasons. First, there is insufficient evidence that Mr. Fisher intimidated the flight crew, and second, there is insufficient evidence that Mr. Fisher interfered with the duties of the co-pilot. First, there is insufficient evidence that Mr. Fisher intimidated the flight crew. Actions such as repeated profanity and
How sufficient does the evidence need to be?
Your Honor, according to the burden in the trial court, there must be proved beyond a reasonable doubt that the defendant intimidated the flight crew to the extent that it would have placed a reasonable person in fear. Actions such as repeated profanity and physical assault that would place a reasonable person in fear constitute intimidation. In U.S. v. Tobacco, we learned that physical assault of a flight attendant and their use of repeated profanity was sufficient to show that the defendant intimidated.
Is that what the court held in that case?
Yes, Your Honor. In this case, in U.S. v. Tobacco, there was physical assault of the flight attendant in which the flight attendant was grabbed and physically hurt by the interaction, and the court found that this was enough to find intimidation.
Well, that's rather different from mere words. That's an actual touching, an offensive physical contact. So is that case really on all fours with the facts of the one we have here?
No, Your Honor, that's what I'm about to show. In the case of U.S. v. Tobacco, the court found there was intimidation because of the physical assault that occurred. I'm about to show that in this case that did not happen, and this is one reason that we do not have sufficient evidence to show intimidation.
Well, so is your contention then that if there's no touching, you can never have sufficient evidence to prove beyond a reasonable doubt that intimidation occurred?
No, Your Honor. Just going off of precedent cases available to us today, we see that these are certain things that could have caused intimidation. We learned that from U.S. v. Tobacco and U.S. v. Hicks. In today's case...
Okay, so that means Tobacco is just not on point then, because it's dealing with the touching. Here we don't have a touching, but words can be sufficient. Am I understanding your argument correctly?
It is certainly possible for words to be sufficient. However, case law such as U.S. v. Tobacco could not show that. I believe on a good faith basis that opposing counsel will come up here and try to draw similarities.
Let's stick to your own argument, Counselor.
Yes, Your Honor. In U.S. v. Hicks, physical intervention would have been necessary to land the flight on time. In U.S. v. Hicks, the flight was not able to land on time because they elected not to use physical force. Unlike both of the aforementioned cases, Fisher did not have any physical contact with the flight attendants, and the flight was able to land on time.
What about the fact that he's in a very confined space that's subject to heightened security restrictions? I mean, the normal freedom of speech would be restrained, and in that sense, you can't just, like, mere words would carry more weight than a threat would, like on the street in an airplane, wouldn't that?
Certainly that's true, Your Honor. But as I'm about to show, the words of the defendant in this case were not severe, they were not profane, and they weren't constant throughout the course of the flight.
What did he say?
Well, on 3 occasions, Mr. Fisher stood up and approached the co-pilot. Mr. Fisher asked when the flight...
Did he walk towards the cockpit?
Yes, Your Honor.
Did he enter the cockpit?
He perhaps was standing at the edge of the cockpit. The record does not reflect that the co-pilot would not have been able to leave the cockpit. Moreover, the record does reflect that the co-pilot did not feel it was necessary to leave the cockpit.
Counsel, post 9/11, shouldn't there be a higher standard for, or a lower standard for what constitutes a threat to the pilots?
No, Your Honor, I do not believe that is true.
Well, we didn't ask what you believe, we asked what it is.
No, Your Honor, it is not true. The events of 9/11, should they mirror the case of today, would perhaps justify seeing this in a different light.
So it has to be a hijacking before it can be a threat?
No, Your Honor, that isn't the case. But 9/11, as I will go into, is very dissimilar from the case today. Sure, in both cases, these were flights. That's about where the similarities end.
But don't we have a significant governmental interest in protecting the integrity of the flight crew from even the smallest threats, the remotest possibility of a hijacking, such as by requiring that cockpit doors be locked and that seatbelt signs be respected by a matter of federal law?
Yes, Your Honor, these are all protections that are taken to protect the flight. However, the record does not reflect at any point that any crew member felt intimidated or that a hijacking was imminent. Now, this is a passenger...
But that's not the standard, is it? Hijacking imminent is not the standard.
No, Your Honor, but in this case, there were very few parallels between the events of 9/11 and the events of this case. This is a 9-person flight that was intended to transport people a few hundred miles, as opposed to a large passenger flight, a commercial flight that was used in the events of 9/11.
I'm not sure that's a distinction with it. Move to your next point, Counsel.
Now this is a passenger flight. One of the goals of this flight was to transport the passengers to their destination. In fact, the record on page 6 reflects that one of the co-pilot's duties was to deal with the passengers. So when Fisher approached the co-pilot was fulfilling one of his duties. Despite this, the co-pilot responded with hostility. At no point did Mr. Fisher touch the co-pilot. Fisher did raise his voice at the co-pilot briefly and may have said the word damn, but there was certainly not the use of repeated profanity. However, to assert that pestering the co-pilot 3 times is sufficient to satisfy the element of intimidation would be to send us down a slippery slope of convicting too many people for such a minor offense. Fisher's actions in this case...
Are you contending that the law is vague then?
Certainly, Your Honor, yes, the law can be vague. The law is vague on what exactly would place a reasonable person in fear, and that is one of the things we're here to decide today.
Well, it's not vague in what places a reasonable person in fear, because that's a question of fact for a jury to decide. But I guess I'm not understanding your slippery slope argument, I don't think. Could you explain it a little more cogently?
Yes, in the instant case, the actions were relatively minor. Mr. Fisher approached the co-pilot 3 times, never touched the co-pilot, hardly intimidated the co-pilot, and for us to intimidate these...
He hardly intimidated the co-pilot.
Yes, Your Honor, there was...
So he did in fact intimidate the co-pilot, but just
No.
a little.
No, Your Honor, the defendant did not intimidate the co-pilot, and what we're here to decide is whether a reasonable person would have felt intimidated in this case. My argument, Your Honor, is that the actions today were so commonplace that to convict something of this would require us to leave police officers stationed at every arrival gate of an American Airlines flight.
Aren't they already there?
No, Your Honor, not every American Airlines flight has police officers stationed at it. For these reasons, I ask
You may have leave to conclude, counsel.
Sorry, Your Honor?
You may have leave to conclude.
For these reasons, I ask that you reverse the trial court's finding. Thank you.
Thank you, counsel. Okay, we'll hear from the counsel for the appellate.
May it please the court. My name is David Lewis and I represent the appellate, the United States. This court should affirm for 2 reasons. First, the appellant, Mr. Fisher, did intimidate the co-pilot, Mr. Griffith. Second, the appellant interfered with Mr. Griffith's duties. Now, Mr. Fisher did intimidate Mr. Griffith because his conduct and words proved to place an ordinary, reasonable person in fear. The definition of intimidation, as quoted in 49 U.S. Code Section 1472, permits that the words and conduct will place an ordinary, reasonable person in fear. In U.S. v. Hicks, the court ruled that the extreme profanity that the appellants used, combined with the angry tenor of their words, would intimidate someone. Like in U.S. v. Hicks, the appellant, Mr. Fisher, on a very small plane, spoke in a loud manner and used vulgar language such as saying, "When are you going to land this damn plane?"
Well, so, I mean, context is everything in the question of threatening speech, isn't it? And so they're in a small space, but don't you also have to pay attention to what's said, not just how it's said? For instance, you can say, "Have a nice day," but you can say it in a way that's very sarcastic and angry and makes it very clear that you hope the person trips and falls downstairs. So the fact that he just said this is not itself sufficient. We also have to take into account how he said it, don't we?
Yes, Your Honor. And how he said it was used, he said this in a very loud manner on a very small plane.
Well, planes are fairly loud themselves with engine noise. Is it possible he was just trying to make himself heard?
Yes, Your Honor, that could be possible, but also at the same time, Mr. Griffith testified that Mr. Fisher was becoming a little bit rowdy, and another passenger, Mr. Smith, testified to Mr. Fisher just being a little bit frustrated.
Well, so people on planes are allowed to be frustrated. Travel is frequently frustrating. So do you violate the criminal law every time you get irritated with the service personnel on a flight?
No, Your Honor.
So where do we draw that line?
We draw that line when we look at U.S. versus Tobacco and how his manner in which how the pitch of his voice was used in comparison to his language, and also, like you have just mentioned, looking at the environment and what this was, and he was not supposed to leave his seat, and he came and approached the cockpit several times and in a very loud manner.
Well, even when the seatbelt sign is on, you're permitted to leave your seat for essential or necessity purposes, aren't you?
No, Your Honor.
For no purpose at all, you're not permitted to leave your seat.
No, Your Honor.
And leaving your seat is automatically a threatening act, is that your contention?
Depending on the context, Your Honor.
So just standing up can be a threatening act sufficient to violate the statute.
It may be so, Your Honor.
If I really have to go to the bathroom,
Yes, Your Honor.
that's violating a federal criminal law, getting up to go to the bathroom.
According to the safety rules mentioned on the aircraft,
Is there a case that supports your contention?
No, Your Honor. Not to my knowledge.
So what's the basis for that contention?
The basis again goes back to the rules mentioned at the beginning of the flight. Before the flight had took off, Mr. Griffiths made safety announcements and also told the passengers that this was going to be a turbulent flight with strong winds and that they should adhere to the fasten seatbelt light.
Counselor, didn't Mr. Fisher return to his seat each time he was asked?
Yes, Your Honor. Although he did return to his seat each time, he did approach the cockpit, not just once and twice, but also the third time.
Don't federal safety regulations require that individuals not stand or congregate in the area around the cockpit?
I am unsure.
Well, if they did, wouldn't that be helpful to your case?
Yes, Your Honor.
And so assuming that they did, what would how would you address that point?
It will be addressed by, I'm sorry, can you repeat your question?
So assuming that federal law requires that individuals not congregate at or near the cockpit during the flight, how would that affect your arguments regarding Mr. Fisher's liability?
That would affect my argument in actually going towards interference, and that Mr. Fisher interfered with Mr. Griffith's duties. Mr. Griffith had several duties, one of them being communicating with the passengers. Also, he had to watch the gauges and monitor the wind speed and communicate with air traffic control directors.
Counselor, is there any evidence that the co-pilot missed any of that information?
Mr. Griffith testified to the fact that he had to divert his attention away from his duties while the aircraft was in flight to deal with Mr. Fisher.
He also has to do that when he sneezes. So this term interference, what does it mean? Is it a substantial interference with the duty? Is it just temporarily forcing them to divert their attention, as Mr. Griffiths did in this case? Or is it any distraction at all? I mean, what counts as interference and how do we know?
According to U.S. versus Hicks, the court had ruled that a cockpit crew member was forced to abandon his or her duties as a result of the appellant's words and conduct. And
Wasn't he forced to actually get up and leave?
No, Your Honor, he did not get up and leave.
So what did abandon his duties mean in that sense?
Abandon his duties will go to the fact of Mr. Fisher approaching the cockpit.
No, I'm sorry, in the case of United States versus Hicks, what did abandon duties mean?
Abandon duties just refers back to the duties of the co-pilot that needed to be accomplished at the time.
Well, let me be more specific. What did the co-pilot in that case do that constituted abandoning his duties? Like what did he have to do to engage with the passenger in that case? Because the necessity of abandoning one's duties sounds fairly severe. It jeopardizes the safety of the aircraft. Taking a second to go back to your seat wouldn't seem to be abandoning one's duties, especially if communicating with passengers is part of your duty.
Yes, Your Honor. But at the same time, the fasten seatbelt light stood as nonverbal communication throughout the entire flight, and he was not supposed to leave his seat.
But so, again, this idea of having to abandon his duties to deal with the passenger, what constitutes interference. I'm not sure that what the co-pilot in this case before us today did, it constitutes having been interfered with to the necessary extent. So where do we draw the line between what is and is not interference?
We draw the line, going back to the precedent case, when we are looking at Mr. Griffith's duties as a co-pilot and who is interfering with those duties. Mr. Griffith had to do 3 things pertaining to his duties. Your Honor, I see that my time has come. I see that it is time for me to conclude. May I continue?
You may have leave to conclude, yes.
Thank you. Mr. Griffith had to do 3 things: watch, listen, and respond. He had to watch the wind speeds and monitor the gauges and also respond to air traffic control directors. He was not able to do any of these things because of Mr. Fisher's interference. The court should affirm the decision of the lower court. If you rule in favor of the other side, you will set a destructive precedent for future cases. Thank you.
Thank you, Counselor. Okay, guys, nice job. Well done. We can give you some feedback here for a couple of minutes. So overall, I'll do just sort of collectively and individually, but you both did very well. You both are very composed under what I would call a pretty hot questioning, at least in terms of its number. And you guys did, obviously, I don't know how much time you had to prepare for this, but you seemed very prepared and did a good job with it, and thought through the case. So I'll start with you first, Mr. Mathis. Okay. You should wait for the Chief Justice to give you a sign that you should begin, instead of just start talking, because we have to make sure the timekeeper's ready and that everyone else is ready to listen. So just a small etiquette note. And then also, it's a very common mistake. You want to avoid saying "I believe" or "I think" because we don't care. We just want to know what the law is and what the case should decide, rather than what you believe. And so it seems like it's like everything that's nice in a normal conversation is not good in appellate arguments. Saying like, "Well, Your Honor," it's like that, and saying "I believe" or "I think" and things like that. You want to say yes or no, and then tell us what it is. So avoid all the things that are correct in normal life, and you'll be ready for appellate argument. And when the court gives you kind of crazy hypos, like with all the 9/11 stuff, get back to your case. Because 9/11 is an extreme example of what can happen when somebody interferes with and intimidates the cabin crew. But we have nothing even remotely approaching that. So get back off that real fast. It's maybe useful to show the purpose of the law, but here we're really doing a little bit more hair splitting than that would require. And then at the end, ask for leave to conclude. When you see the time go up, you should stop, and then, "Your Honor, I see my time has run. May I have leave to briefly conclude?" And then give us like 1 or 2 sentences. Mr. Lewis, also, you did ask for leave to conclude, which was great. But your conclusion after time was very long. It was well written and well prepared. It was an effective conclusion. But after time, it needs to be a little shorter. And also, be wary of calling the court "you." Either the court generally, or like one of the judges, you should always refer to them as "Your Honor" or "the court." Even if you're saying, "Well, as Your Honor said." It sounds weird, but it's the technically correct way to do it. Watch out for getting overextended also on the bathroom thing. Like, getting up to go to the bathroom probably doesn't threaten the cockpit crew, and it may in a technical way, but you'd have a lot of trouble convincing most judges of it. Unless they're like super law and order, like everyone on the plane should be sitting down quiet facing forward the entire time. Then that was, I saw where you're trying to go with it, but sensing where to back down is a difficult thing, and it's just a practice thing. Yes?
Well, I don't have too much to add. I thought you handled his questions very well, because I've been in your spot and I've had him ask me questions. So I thought you did very, very well. I didn't have too much of that. It's okay to concede a point. I think his seatbelt questioning, you could have said no, it wouldn't have counted there, and it's also okay to say I don't know. That's all I had.
Yeah, Bailey hit most of the points I was going to note. I think you both did a good job going back to case law occasionally. When I was up there, I kept forgetting to do that. I know you have these really strong facts sometimes that help you distinguish things, and it's good to keep going backwards into those to support a point. And you both did a good job fielding Bailey's questions. Those were much harder than I went up against, and I was still nervous. But do watch for when you're getting off track. And when you're going away towards hypos that aren't really relevant. It's okay to say, Your Honor, that's a great question, but that's not the case we had before us today. I wish I had said that during my oral argument, because I got caught in a trap.
Although don't say that's a great question, because I'll say, yes, I know it is. That actually happened to somebody in my first year torts class. They were trying to stall when they were cold called, and I said to Professor Ziegler, "That's a great question, Professor." And she said, "Yeah, I know it was. In fact, when I thought of it this morning, I said, 'Damn, girl, that is a great question.'"
But it's okay to say that's not what we have before us today and then get back on track. That's a good way to keep from going down a rabbit hole. But other than that, you both did very well.
Thank you.
Now go relax, process,